Hi guys, welcome to the HOMEIS frequently asked questions session with Mr. Rajiv Khanna. We are hosting this session to answer some questions that our HOMEIS members have asked, and Mr. Rajiv Khanna has been very kind to help us and answer these questions for us. Um, so, hi, sir, how are you doing today?
Ji, Pranam Varsha ji, how are you?
Very good. Thank you so much for taking time out and helping HOMEIS members with these queries.
My pleasure. Can I interject for just a second?
Sure, please.
There are actually two other lawyers with the same name and the same spelling that I know of.
Okay.
One is in Falls Church, another one is in New York. So
Okay.
I always write my name Rajiv S. Khanna
Okay.
because I don't want people to go bothering other lawyers. So just to make that clear.
Perfect. Thank you. Thank you for making that clear. We'll in fact have the banner edited for the next session. So I'll start with question, Rajiv ji, and first few questions that we have from our users are related to H-1B visa.
Yes, ma'am.
So the first question goes like, I work for a non-profit in a STEM position and I have a STEM master's. I've heard that non-profit H-1B is guaranteed and I don't need to go through the lottery. But I've also heard that once you are on a non-profit H-1B, you cannot switch to a normal H-1B, essentially restricting you to the non-profit industry. So can you
Okay.
just throw some light on that?
Well, first of all, there is a fundamental error in presupposing that all nonprofits are entitled to an exemption from the quota. They are not. Only quota exempt, quota exempt organizations, nonprofit organizations are those that are nonprofit research organizations. So the word research is not to be forgotten. Unless the organization is geared towards some kind of research, whether it's in the social sciences or hard sciences, anything as long as there is a research orientation. Number two, if you process an H-1B for a quota exempt organization, any quota exempt organization, it can be a nonprofit research organization, a state or federal government research organization, or an institution of higher learning, or institutions affiliated with institutions of higher learning, which is the entire gamut of exempt organizations. Whenever you get an H-1B through them, it is essentially a non-entity for your quota H-1B. It doesn't hurt your chances. It simply means it has no meaning. If you want to go to a for-profit organization, you will have to go to the quota just like regular ordinary mortals do.
Okay.
Okay? So it doesn't hurt you, it just doesn't help you. But there's a very odd quirk in the regulations. This is a prime example of badly written laws that create bizarre consequences. What is that? Well, let us say I'm working for a quota exempt organization
Mm-hmm.
on a quota exempt H1. Oddly and weirdly, I can take a second job with a quota organization. So if I'm working, let's say, for X organization that's quota exempt, but there is another organization Y with whom I want to work concurrently,
Mm-hmm.
I can without being subject to the quota as long as I maintain both jobs.
Okay, so you're free to have two jobs at the same time, and they're different. Like the visa would be one with quota and one without.
But
Okay,
think about how weird this is that you are exempt from the quota from job one.
right.
Job two, which is a quota subject job, is allowed concurrently as long as you maintain both jobs.
Gotcha.
So theoretically, you could pare down the number of hours for a quota job down to 5 hours a week and do
Mm-hmm.
35 hours a week in a quota organization. Technically, theoretically, how does the government deal with that? It hasn't been tested, but we have tested concurrent H1s many, many times. That's accepted practice. So that, in a nutshell, is how it works for quota organizations or non-quota organizations.
Okay, I'm sure this will help understand this particular situation. The next question is, I'm on H-1B visa and field extension, which is pending with USCIS. Due to some company policy, I'm not able to apply for premium, but I have to travel to India in April for family reasons. Can I apply for H4 visa dependent of husband who is also on H1 from India to stay here with him while my H1B extension is pending? Will it be possible to come again on H1B once it gets approved?
I think I have this question in front of me. Let me also see.
Sure.
Who recently got H1 extension approval?
Mhm.
Oh no, this is another question.
Yeah, this question starts with I'm on H1B visa and
Okay.
filed extension,
I
which is
don't think we have them in the same order. So
okay.
I'm on H1. I filed an extension. I want to travel to India.
Mm-hmm.
I want to come back on H4. Is that what I'm doing?
You are reading question number. If you look at the 18th row,
18.
yes,
Oh yeah, I see it.
yes.
Uh, I am on H1B visa and filed extension, which is pending with the USCIS. Due to some company policy, I cannot apply for premium, but I have to travel to India in April. Okay, can I apply for H4 visa to stay with him while my? You can, but it's not advisable. I'll tell you why. There are two components to travel when an extension is pending. One component is the ability to come back to the US, and the other is the ability to continue with the pending application without major incidents. Both have to be managed because you have an extension pending. When you have an extension pending, if you have a visa stamp, you can just travel on that H1B. It does not hurt your extension.
Okay.
But if you come back on H4, you have interfered with the pending application to the extent you will get the H1, but you won't get change of status or extension. In order to get the extension, you would have to go outside for visa stamping, which is painful. Your lawyers can, once you come back on H4, apply for change of status again if the H1 is approved. But the change of status is exactly the same paperwork all over again. So you're running the gamut twice. You're
Right.
running the gauntlet twice, sorry. I'm not sure that's the best thing for you. So I would say speak with your employers.
Hmm.
Under the law, I personally, in my opinion, an employee can pay for the premium processing if it is being done for their convenience, not for the convenience of the employer.
Oh, yeah.
So if you are paying for it, I don't see why the employer would have any problem, especially if you can explain to them that if I travel, which I have to, if I travel and I come back on H4, you
Right.
guys are going to have to file my change of status, which is like filing the whole application all over again.
Gotcha.
Okay. So I would say talk with your employer, offer to pay them. But if you come back on H4, which you can, then be prepared to either go for H1 visa or apply for H4 to H1 change of status.
Okay. Okay, that's great. I'm now going to go in the order, Rajivji, so it's convenient for us to tackle these questions more
Gee.
smoothly. The next question is currently I'm on CPT. Can my employer file for an H1? And if it gets picked up, do I have to continue with my studies? Also, my CPT ends in October 2020. Can I apply for a pre-completion OPT?
Well, first of all, CPT has become a very odd element of law.
Mhm.
The government, without notice to anyone, changed their policy from what used to be unlimited CPT to limited CPT. The traditional understanding for all lawyers and for the DSOs, which is the designated school official, these are DSOs are school officials that have been trained by the USCIS to help students. So they are the experts in student related laws.
Yes, sir. Hmm.
Without notice to any of the stakeholders, the DSOs, the students, the university staff, government threw out a policy that said you could have unlimited CPT. Now they say CPT, OPT combined at any one level cannot be more than a year. So if you have, for example, taken 3 months of OPT or 3 months of CPT, you would only have 9 months of OPT left. So let's say you've taken 1 year of OPT. Can you now get CPT? And the answer is, according to their brilliant change in direction without notice to anybody, they have decided no. So it's like living under the times of Nero, the Roman emperor, where things were done by edict rather than by law. This is a lawsuit waiting to happen. One of these days, somebody's going to have the resources and the time to actually take the government into court over this. But until that happens, remember that your CPT is highly suspect because this change in interpretation left the DSOs unprepared. The DSOs are still giving you CPT, but it may not be legal. So what's the net result? So let's say I have somebody on CPT and apply for their H1. They'll get the H1, but they'll have to travel to India for visa stamping or to a third country.
Okay.
So going back to this question, currently I am on CPT. Can my employer file for my H1? The answer is yes, but not knowing all the facts of your case, it appears very likely that you might have to travel outside USA for H1 visa stamping, which is another can of worms, which means when you go for stamping, you don't know whether they're going to take 1 week, 2 weeks, or 6 weeks, as long as you're prepared for that. Remember, you can be working from your home country. That's not an issue. So can they do it? Can they file the H1? Yes, they can. Will you be able to get it within the USA? Doubtful, unless you meet the new policy requirements. And the third question was...
the CPT ends in October, so if the person can apply for a pre-completion OPT?
The answer is as long as it doesn't exceed 12 months, your OPT can be applied. There's no such thing as pre-completion OPT. I think they've stopped that.
Okay.
Or maybe they call it something different. It is OPT, but if you take it, I don't remember exactly what the rules are. But just remember, CPT and OPT combined at any one level cannot be more than 12 months.
Okay.
One level means if you're doing a master's degree, then at that level, you only get 12 months. If you go to PhD, you get 12 months again. But if you go to another master's degree, you won't get any more time.
Okay. And is it same for the STEM and non-STEM students? Or
Same.
Okay.
Same. The only difference with STEM is that you get 2 extra years of STEM OPT. But it doesn't change the CPT OPT distribution.
Okay, gotcha. Okay. Let's move on to the next question. I have a friend who is undocumented but has a 4-year-old USA
One
citizen.
second.
Sure.
Let me go back to, she had some other questions.
Sure.
She says, can my employer file for my, if it gets picked up, do I have to continue with my study?
Yes.
So let's assume that you've taken less than 12 months of CPT and your H1 was filed, it got picked up. If your status expires after April 1st of any year, you are considered to be in gap extension. Now, the question is, do I have to continue going to school? And the answer is, I think so.
Okay.
Why? Because the gap extension is simply an extension given to those students whose practical training is expiring before October 1st, which is the beginning of the H1, right? So that doesn't mean that you become exempt from requiring or the requirement of maintenance of status till October 1st.
Right.
So the short answer is yes, you would have to maintain status till October 1st.
Okay.
Then she says, oh, that was a pre-completion. Yeah, I think we've covered it.
That's what we answered.
Yes, ma'am.
Shall we move on to the next one then?
Please.
Okay, great. I have a friend who is an undocumented immigrant and has a 4-year-old USA citizen child. My question is there a way for him to apply for asylum or any other way to get residency based on his child?
I did only one political asylum case in my entire life in 1993 as a favor to somebody, to another lawyer.
Okay.
I don't have any clue of political asylum laws. Our practice is in the legal immigration, documented immigration area.
Gotcha. No problems. Let's move on to the next questions. I recently got H1 extension approval in the premium process. H4 also applied for an extension, but my employer was ready to bundle H4 EAD. Is there any way H4 EAD can be renewed based on the H1 approval and H4 receipt? fingerprints and the biometrics were done a week back.
I think there's a typo here. Maybe they forgot to add was not ready to bundle. So I'm
Okay.
assuming that the H4 was filed, but the EAD was not included in the package. And the answer is, question is, can I file an EAD application with just the H4 receipt? I don't see why not. The answer is yes.
Okay, great. I live in New Jersey for past 9 years and I'm married to a US citizen and we have a 2-year-old baby. I am on C1D visa. So what can I do to get a green card in my case?
I have no clue.
Okay.
I know this, that the crew visas, C and D visas, create a bar that you cannot adjust status within the United States. But is there an exemption to the bar for spouses of US citizens or immediate family of US citizens? I don't know. I'll have to look it up.
Okay.
But I don't think there is.
Okay. Well, I hope that gives some sense of, I guess, direction and maybe we can look at the answers to help them later.
Right.
The next question. I am a US citizen and applying for my parents' green card. My parents are here on tourist visa. I got a letter from USCIS that they need a birth certificate, non-availability of birth certificate to give final decision, and gave me 87 days to send all these documents to them again. I got a non-availability of birth certificate from Indian Embassy here in New York. Would that work for my parents? So he could not really produce a birth certificate, I'm assuming.
There are two issues here, Varshaji. There is one that's unstated and one that's stated. The unstated issue is when anyone enters the United States on a tourist visa, their disclosed intention is that I'm going for a brief period.
Right.
But if you then apply for a green card, the government can come after you for fraudulent entry. The fraud is committed either, well, I would say both. They can pick either one. When you obtain the visa, if you obtained it just before coming in, if you have had a preconceived intention to convert to green card, they can say that that's illegal. That's a misrepresentation. The second point at which the misrepresentation can be alleged is when you enter the United States. So at the airport, if the CBP officer asked you specifically, why are you coming? And you said, I'm just coming to visit my family, but it was your intention to apply for a green card, that can be treated as a misrepresentation.
Gotcha.
So there is case law that says that these elements of misrepresentation should not be applied to immediate relatives, like parents. But I just finished doing one case in New York where they created a big stink about this, and they have permanently barred the parents from entering the United States. Of course, I think they're going to lose in court. We are fighting that.
Yeah.
They're going to lose, I'm pretty sure, in court, but it is a problem. How do you get around that? So she's not asked that question,
Right.
but I think it's important for the community to know. I have it in our blog, immigration.com, as well in the frequently asked questions.
Okay.
We dealt with this issue in detail.
Okay.
The first thing is, remember, it is the intention of the applicants that matters. That means your parents, not yours. If you have the intention to apply for their green card, keep it within your own mind.
Right.
Don't discuss it with them. They should not have a preconceived intention.
Gotcha.
Second, don't do anything for at least 3-4 months after they enter.
Okay.
Because if you try to adjust status within 90 days of entry, it's presumed to be a misrepresentation.
Okay.
Okay. So better to just have a consultation with the lawyers after 3 or 4 months of their entry.
And then go ahead with the process.
Leaving that aside, now the birth certificate is a very common problem in the community, especially the Indian community. When I say community, I mean the community of all people interested in immigration.
Yeah.
I do not mean just the Indian folks or Pakistani or Bangladeshis.
Yeah.
What happens is, I think in India before 1970, birth certificates were not required. So in other words, if you had a baby, you didn't have to run to the registration and get the baby registered. There are two aspects to remember here. One, this was not required. And two, if you register the birth 10 years later, it doesn't count.
Oh, okay.
I've seen cases where people went and got the birth registered later. It doesn't count. It has to be contemporaneous, reasonably contemporaneous with the birth. So if somebody was born in 1970, we want it done within a month or two, if not a few days.
Okay.
Now, number one thing I would recommend, I think you should hire a lawyer. I don't think you should do it yourself. But if you are adventurous and you want to take a shot at it, first thing, do a search. State Department has a list of availability of documentation.
Other documents that can be presented.
They have a list of documents that are not obtainable for India.
Okay.
And birth certificates for people born before 1970 are specifically listed there.
Okay.
Okay.
Yeah.
So now you establish that these documents are not available. Second thing you should do is, and getting a non-availability certificate or statement from the consulate is not going to help you. You should get a non-availability from the municipal corporation or the village panchayat of the city or the village your parents were born in, saying that we have no record of this birth.
Okay.
We give it a fancy name, non-availability certificate. It could be just a scribbled line on a piece of paper, as long as it is on the official letterhead. We have no record of this birth. So you've got the State Department website saying these are not available. You've got a non-availability statement. Now what you do is you get 2 affidavits from people who were alive when your parents were born.
Okay.
They don't have to be adults when they were born.
Okay.
Okay. And they can give you affidavits. If you don't have the affidavits also, then you can bring in tertiary evidence. So the primary evidence is the birth certificate.
Right.
Secondary is non-availability combined with affidavits.
Right.
And then the tertiary is things like ration card, school living, as well as Aadhaar card has date of birth. I don't know.
I am not sure. I think, yeah.
So basically, you can then go to school living certificates, go to tertiary documentation.
So
Usually, this is not an insurmountable issue, but it's a painful issue because you have to go through a bunch of documents.
Right.
But getting something from the consulate is not going to work.
Oh, okay. So, well, that was helpful. At least we know if they do not get it, then what is it that they should do in this case?
Yeah. In the U.S. regulations, in the USCIS regulations, there is a specific mention of acceptance of secondary evidence. If primary evidence is not available, you have to provide a legitimate excuse why it is not available, and then proceed to give secondary evidence. So the secondary then goes on to tertiary, because if you can't get secondary also, then you get tertiary evidence.
Right. Okay. That's something to keep in mind. The next question would be, for the underage immigrants, after I-360 approved, how long does it take? How long does it take to approve I-485?
360 is for special immigrants. That applies to a whole range of people, including religious visas. So there's all kinds of special visas. The processing time, I wouldn't know, because the times can also depend upon the local offices. So what you should do is, you should, in the search bar, and I don't want to name any particular search provider, I don't want to say Google or Yahoo or any of those, whatever you
use on daily.
Right, just type USCIS processing times.
Okay.
Immediately it brings you to a page where you can pick the sub office where you're supposed to go for an interview. So if, for example, if you were in Newark area, it will say Newark sub office. Look at the 485 processing times. That will give you some idea. These are not very reliable, but they are indicative.
Indicated. Yeah. Okay, great. Let's move on to the next question. My conditional green card expires in August 2020. Applied on the basis of marriage to a US citizen. When can I apply for the removal of conditions? And is this process tough in comparison to the one to get your conditional green card?
The conditional green card, removal of condition has to be applied 90 days before the second anniversary of your green card approval.
Okay.
Okay. So if your green card is approved today, 90 days before the second anniversary from today, I would
Mm-hmm.
have to apply for removal of condition.
Okay.
Is it difficult? That depends. If you have a straightforward case, the best certificate of good faith marriage is having children. If you got a
Right.
kid or two, great. If you're living together, easy to prove.
Mm-hmm.
It becomes more difficult, more challenging if you're already divorced or in the process of getting divorced, because you can
Okay.
still get the condition removed. If, as long as you got married in good faith, later on the
Mm-hmm.
marriage did not work out, you can still get your condition removed. Okay.
Okay.
I would suggest look at the form I-751, which is the form you use to remove condition, and read the instructions on the evidence that you need.
Okay.
So as long as you can procure and produce that evidence, you should be fine. So it's not difficult. It's a little document intensive.
Okay. I just want to ask one question here, Rajivji. So you said you can apply for the renewal of the green card, the conditional green card, 90 days before your marriage, the second anniversary, or
No,
it
no.
is
Green card approval,
green
anniversary of the
card?
green
Yeah.
card approval, not
Okay.
your marriage. We
Okay.
don't really care about it.
No, because yeah, that's exactly what my question is. Because that was like it should be for green card.
There's going to be no candlelight dinners from the US. So,
Right. Okay, let's move on to next question. This one is related with F1 visa. It says, I'm on F1. The current I-20 is valid for 2 years. If I extend it by 4 months to complete my STEM degree, how many years OPT can I get?
if you have a STEM degree, you would get STEM OPT just like everybody else, which is for 2 years. The STEM extension would be 2 years. I'm
Right.
assuming that's the question.
Okay, yeah. Okay, so it will be for 2 years. All right. The next question we've handled, so let's move on to next one. Um, if my I-129 mentions consulate, say Mumbai, for submitting information, can I give an interview in Delhi?
The answer is yes. It has been so for last many years that
Mhm.
in India, you do not have to go to the specific consulate for which you are scheduled
Okay.
because the documentation is all maintained in a database called PINS.
Okay.
The database is available universally, it's in the cloud. So you could go anywhere.
And they can pull
That's
you.
the general rule. But the question is, what are the logistics? Reach out to the consulate where you are going for the interview. Email them. You may not be able to get them on the phone. You can try that as well.
Yeah.
And also reach out to the consulate where your case is pending. See which one races to answer your question first.
Okay. Gotcha. So they'll just have to make the arrangements accordingly before they
That's
just
right.
walk in. Okay,
That's
great.
right.
The next question is, I had an EAD when I was on J2 dependent visa back in 2014. Now I'm on H4. Do I have to apply for a new EAD or is it just a renewal for me?
The question is just about filling a form. Just as a matter of caution, normally we can't help you fill out forms because every form has a place where it says signature of the person who helped you prepare the forms.
Right.
We can't really ethically tell you how to prepare forms, but generically speaking,
Mhm.
if somebody has had an EAD before, but in a different category, is it more accurate to say that this is a new EAD, or is it more accurate to say this is an extension? Not really an extension because it's a different category.
Right.
Okay, but not really a new EAD because you've had one before.
Hmm.
So the best thing to do is, I would probably, in a case like this, file it as a new EAD.
Okay.
It's not really in the same category. I think that's more accurate. And I would put it in a cover letter. Hey, you guys, by the way, I had an EAD before, and here's a copy.
Okay. So dropping in an extra word will help. Okay. Let's move on to next one. I was on J1 visa here and did not finish the J1 visa. I'm assuming the person's trying to say that it did not get over and applied for a B1 visitor visa in which I have booked my flights for this April. But now I have enrolled myself in community college and will be going to change my status again from B1 to F1. Can I still go back to travel and enter the States?
Okay, there are several stated and unstated problems in this scenario.
Okay.
First thing we do not know is there are two kinds of J1s. Varsha, by the time we are done with this, you'll be 3/4 a lawyer.
I
I'm
know.
getting a little nervous about my own job.
I probably will come and assist you.
So J1s come in two flavors. There are those that are subject to a home residency requirement.
Right.
And this is a throwback to the communist days. The idea was we'll bring in people from, let's say, communist Russia and educate them here, but then they have to go back to their country. But when they go back, they'll be ambassadors of our goodwill. They'll tell everybody in Russia, look how nice the Americans are. So that was the idea.
Okay.
That's a carryover from a time, and it's just really another one of those behemoths that no longer belong in modern immigration law.
Okay.
But modern under immigration laws means something that we haven't changed in 100 years. Anything over 100, less than 100 years old is modern.
Okay.
But that said, J1s come in two flavors. Those that are subject to that residency requirement that you've got to go back to your country, and those that are not.
Okay.
So let's take the first case where you are subject to the home residency requirement. The fact that you did not complete your J1 stint does not absolve you from the home residency requirement.
Right.
As I recall, that regulation is called 8 CFR 212E. It's called the 212E requirement. The 212E requirement not only does not allow you to get a work visa for as long as you've got that J1 condition hanging over your head, and that can, by the way, only be discharged by one of the two methods. Either you go back to your country of last permanent residence for 2 years, or you get a waiver.
Okay.
There are only 4 ways to get a waiver. That's a whole other discussion.
Okay.
But J1 waivers can be complicated. So if you're not subject to the waiver, then it's a different ballgame. But if you're subject to the waiver, you can't even change status. So if you came on a B1, you can't change to F1.
Oh, okay.
Because you have that 212E requirement. You could get an F1 visa and come back, because 212E only stops you from getting L, H, and green card visas.
Okay.
It doesn't stop you from getting like an O1 visa or an F1 visa, but you cannot change status within the USA.
Oh, so they have to like leave the country and then apply.
That's correct. Get a visa and come back. So let's put that aside for a second. Let's say you're not subject to the 212E. Now you're coming and trying to change B1 to F1. That's misrepresentation. We talked about that.
Yes.
Because you're telling the government, oh, I'm just going to go in for a short time, and then you start an admission into a bachelor's degree or a master's degree.
Right.
So if you try to change status within 90 days of entry, they can consider that to be fraud.
Okay.
They can consider that to be fraud even later on if you had that preconceived intention. So be careful with it.
Right.
And also, as I recall, there's a regulation on the books that if you want to change status, I think you have to declare it at the airport for student visa people. So it's a little complicated. Do your homework before you come in. Don't be caught unprepared. Make sure you're not subject to the 212E, and then make sure that whatever declaration has to be made at the airport have been made, and be aware that it could be an issue of misrepresentation.
All right. Well, there seems to be a lot of work this HOMEI user needs to do before he makes a decision.
Yes, ma'am.
Hope he does that after listening to the answer now. The next question is, what is the national interest waiver visa and requirements to apply?
I can write a book on that.
Oh, really?
A 2-volume book on that. I'll try to address that as best as I can. But let me go back and talk about the complications of immigration law. I just want people to realize something. There were 2 things that are quite patent once you start practicing immigration law. One, it is a very complex area of the law with lots of moving parts. You have the law, and then you have an exception, then you have an exception to the exception, then the exception to the exception of the exception. It's just crazy how much stuff there is to know. In our office, unless you have worked as a lawyer for at least 5 years, you're not allowed to give any advice to any client. Because until you've been fully immersed for 5 years, it's not possible to really give good advice.
Okay.
Secondly, it is often counterintuitive. So often our college professor, law school professor used to say about immigration law that if you get an exam question on immigration law and you just cannot figure out what the answer is, take a breath, go wash your face, come back, decide what is the most common sense thing to do, and then write the opposite of that. Because that's probably the answer.
Oh my God, okay.
That's the way immigration law works. It's considered to be one of the 3 most complicated areas of the law in this country. Security Exchange Commission regulations, under which Martha Stewart went to prison. which is the stocks and bonds, how to conduct those businesses,
Uh-huh.
tax laws and immigration laws. Absolutely bizarre. Okay, so keep this in mind.
Mhm.
Now, going to the topic of national interest waiver. What exactly is a national interest waiver? I actually have on my blog on immigration.com, I drew an infographic which
Mhm.
has broken down the entire law and explains to you what the old law was, what the new law is.
Okay.
Let's begin with a very simple statement. A national interest waiver is simply a waiver of the need for a job requirement. Normally, when you get a green card, you need a job offer.
Yes.
National interest waiver is that certain jobs we can exempt from the requirement of a job offer because it's in the interest of the nation.
Okay.
Okay, and they come in two flavors. One is the request of an interested federal government agency, not state government, federal government agency. So, for instance, we have cases where there is a scientist working on an area which is of intense interest to the US armed forces.
Mhm.
If he can get a letter that says, we need this gentleman, you can get them a green card based upon that. Just one letter. But there is a caveat, the letter has to come from an officer high enough that they speak for the whole agency.
Okay.
It can't be just your manager at work.
Right.
Typically, as I recall, for the armed forces, it used to be the Undersecretary of Defense, which is as high you can get without actually going into a Senate confirmed position.
Mhm. Okay.
So that's for interested US government agency people. Most mortals, ordinary mortals, take the second route, which is I am going to do something which is the interest of the nation.
Mhm.
I am well, not uniquely, I'm well qualified to do the job.
Hmm.
And there is interest in the United States in that, in my job, my project. And the last item is that when you do analysis of the advantage to the US system of requiring a job and labor certification and protecting US interests by letting go of the job requirement, just giving me the green card, the balance is in favor of just giving me the green card. So there's four things they're looking for. Whatever you're doing is in the national interest, not local interest.
Right.
For example, if you are doing something for a small company and you created an invention, it's going to help the company make a lot of money,
Hmm.
we don't care.
It's for the nation's interest. You need to prove that. Hmm.
Second, I'm qualified to do the job. I just got a national interest waiver for a French scientist. She was working, if I remember correctly, on in some area of immune system suppression, and how to both do it and get over it. So when you do organ transplants, you need to suppress people's immune systems.
Uh-huh.
And by the way, my first degree is in biology, so I'm a little bit of a bio nerd too.
Okay.
And if you, at the same time, if your immune system is compromised, how to bring it up. So she had some work in that area. Either we did a bunch of these cases. So I think one of those cases was this. We were able to show that number one, this is in the national interest. This is not a local thing.
Right.
Number two, she has a PhD. She's been doing this for a while, so she's well qualified to do the job.
Right.
Number three, there was a job offer from the lab where she worked. They
Uh-huh.
wanted to give her a permanent position, but they couldn't because she was on a student visa.
Right.
Okay, and because the lab is a grant-based position, it may not be a permanent position, so labor certification is not appropriate. So all four elements are met,
Dash. Hmm.
right? It's national interest, I'm qualified, there's interest in my work, and it's best to give me it rather than make me go through the labor certification process.
Right.
So that's an example of a national interest waiver. And the third part is if you're going to create lots of American jobs. So if you're coming in with a great business plan and you're going to create 10, 15, 20 American jobs, it doesn't require any particular amount of investment, just a great business plan.
Okay.
Okay. But remember, national interest waivers for people who have the great good fortune to be born in India is no good.
Hmm.
Because it's EB2 category, it's still going to take 15 years.
Years. Long time. The part where you mentioned that it could be a business as well, and you can employ people, right? So in that case, out of curiosity, I want to ask you: when they employ somebody, it has to be the locals, the nationals. That's something
US jobs,
that
yeah.
will be
Yeah,
mandatory.
if you bring your uncle and your aunt and your cousins, that
That
probably
would be
doesn't count. But if they are U.S. Workers, then it might count. There are some green cards for which we don't count family for as job creation, but the general idea is that you're creating jobs in the local economy.
okay. Gotcha. Great. That was very informative. I'm thinking, in fact, Rajivji, maybe it's a good idea. The infographic that you mentioned you've written down, I would love to share that with our users as well, or the link of that, so they can be directed to
Sure.
immigration.com and read more about it.
Sure. In fact, I had a recorded discussion with a veterinary doctor who is India born, but a citizen of Canada, and I recorded it for the community
Mm-hmm.
of how many options there are. For example, creating your own practice, investing, coming on an E2 visa. E2 visa is an interesting visa. It's called a treaty investor visa. It
Uh-huh.
doesn't require $1 million or 1.8 million, $1.9 million. Even with a couple $100,000, you could start it. The problem is India and USA don't have that treaty. So what some people do is they get citizenship of a third country like Turkey or Cyprus. Well, there's a bunch of them who will give
Mm-hmm.
you citizenship with just some investment, and then you can do an E2 visa based upon that. E2 visa is good pretty much in perpetuity. You can keep extending it as long as you need.
Okay.
So that's something to consider. So I'll actually once I have that up on YouTube, I'll let you know.
Sure.
I'll have to create an infographic for that as well.
Okay. Yeah. Sure. Let's share that once it's ready with our users as well.
Right. So because it was why is it important is that people who are on H1B and
Mm-hmm.
they made lots of money, but they are stuck in this problem.
Right.
Is there an investment option for them? And the answer is absolutely. We actually just did an EB5 based investment green card for somebody who came on an H1B, made good money,
Mm-hmm.
learned how to invest money,
Uh-huh.
and made lots of money in real estate. And then we took all that money and put it in a holding corporation and created an EB5 case based upon that, which got him his green card.
Okay.
So, so therefore, there are options for H1B holders who have a lot of money and they want to invest the money and create jobs. So that's something to think about.
And take a different route to attain their green card.
Yes, ma'am.
This is that. Great. That's great. The next question we've answered already, so let's skip that one. Uh, the next question is: I filed for I-485 green card and I-765 work permit together after being admitted in the USA on a K1 fiance visa. USCIS received the case on 25th of November 2019. The biometrics were completed on 19th December of 2019. Any idea by when can I expect my green card and EAD?
The
Interview.
same answer as we gave earlier, which is go to your favorite search engine, type USCIS processing times, and did she or he say where they live? So let's say you're living in Newark, so you go to the sub office Newark, go to select form I-485, select sub office Newark, and that'll give you approximate times.
Okay, great. The next one is: I have a question. I had an EAD and I was on J2 dependent visa back in 2014, and now I'm on H4. Do I have to apply as a new EAD? Oh, I think we just answered this. It's a
Yeah, we
duplicate.
can answer this.
Yeah, sorry. The next question: I'm a US citizen. My daughter is 16-year-old in India. She is Indian. She has a US visitor visa, so she is in India. Okay, I'm planning to bring her to the US to study further. I also want her to be a naturalized citizen before she turns 18. Can I bring her to the US and then start her N600K application? What happens if her naturalization process is not completed and she completes 6 month period of her visitor visa? Okay, so there's a time. Please advise, yeah.
There are two aspects of this question that I can answer. One that I don't know. I don't remember. I have to look up the law.
Okay.
N600 is for those children for whom you apply for naturalization within a certain age time. And one of the requirements is that one of the parents, US citizen parents, should have lived in the US. I don't remember the exact details of the requirements. And I don't even remember if you have to bring them in on a green card or they can come on a tourist visa.
Visa.
So leaving that part aside, the other questions I can address, one is, let's see, she said, planning to bring
US to study further.
to study further.
Yes.
So one of the obvious options is to just bring them in on a student visa,
Yeah.
right?
Mhm.
And by the way, student visas are also available to high school students if the school that they go to is authorized to issue the forms required for a student visa. It's called I-20.
Okay.
So many schools, especially the good ones, I wouldn't say the good ones, let's just say some of the ones that are used to having foreign students,
Mhm.
have gone through the process of acquiring permission from the USCIS to issue forms I-20. So if your school can issue form I-20, you could just bring the child in on a student visa.
Student visa.
That takes care of all your issues. Okay?
Right.
Now the question is, if they come in on a tourist visa and the tourist visa is about to expire, just apply for an extension.
Right.
You may not get it, but at
Right.
least you would not be out of status.
Right.
So about a month or two before the tourist visa is going to expire, apply for an extension. The extension is going to stay pending for 5 months. By
Okay.
that time, the N600 would be sorted out.
Okay. So during the extension process, the things should fall in its place. Okay, great. The next question is, I'm a green card holder and I'm going to India. Can I apply for a re-entry permit for 2 years? How long the process will take?
Okay, so it's important to understand the context of a U.S. green card holder stay outside USA.
Mm-hmm.
If you're a green card holder and you leave the USA for even 1 day with no plan to come back, technically they can take away your green card even if you return the next day.
Okay.
Because at the point when you left the United States, you had no intention of coming back within a certain specific period of time.
Right.
Okay. So the green card is a precarious benefit. Don't think just because you have a card in your pocket, it can't be taken away. Second thing is that there is a procedure in the laws which is called re-entry permit, that if you have to go outside USA for a specific period of time, which is bound by an event likely to happen within that period.
Mm-hmm.
So for example, I'll give you an example from one of our cases, a 2-year contract to teach in the Middle East.
Okay.
Okay, it's going to be over in 2 years, right?
Right.
So I can get a 2-year extension.
Right.
So if you have, or I want to dispose of my property, I've already talked with the realtors, they're working on it, or I'm selling my business, it should be done within a couple of years. Or I'm going to take care of my mom and dad, and they're going to just be needing my help for 2 years.
Right.
It will be indefinite, right? Theoretically, as a practical matter, they don't bother too much. So you can apply for a re-entry permit, and the rule is you don't have to wait for its grant. You can leave after you apply.
Okay.
Okay. So the way this works is, first you send in the application. In 5 to 6 weeks, you'll be scheduled for biometrics. They'll take your picture, they'll take your fingerprints, and then you can leave. The card can be sent to your lawyers. It's like a passport. The re-entry permit can be sent to your lawyers,
Right.
or to any of your friends in USA or family, or it can be picked up at the consulate where you live.
Okay.
So if you live in UP, you can go to Delhi and pick up the re-entry permit there.
Okay.
So you don't really have to wait for it to be approved to leave.
Gotcha. You can apply for it, and then while it's in process, you can leave.
Right.
Okay.
For people who are actually going to work for a US company like Google India,
Right.
one of those cases which I know, you can actually even preserve the period for your naturalization. And that's a separate form called M470. Just keep it in mind that you might, if you're going to there are four or five criteria, but the most common one is that you're going to work on something that addresses US import, export, or US commerce abroad. So typically that means you're working for a branch of a US company.
Okay. Interesting. Let's move on to the next question now. My employer is filing a petition for my H1 this year. My F1 status is valid till 2022, though my passport expires in 2020, July of 2022. Will this affect in any case when my H1 gets picked up from for the further processing in the new lottery system?
So, in other words, the question is, does the validity of my passport affect my H-1B? The
Right.
answer is no, it does not. Just
Oh.
make sure you apply for a renewal. You can
Mm-hmm.
do that. I don't know how far ahead of time. I think it's 3 or 4 months. Contact the U.S. consulate, the Indian consulate in USA. Have them start the process. I think it's fairly quick, and they also have an expedite. It doesn't really matter as long as, so it doesn't affect your H-1B. Don't worry about that.
Person need not really worry about it, but get the process
Yeah.
started. Okay, great. The next question. My mother surrendered her green card in 2004. Sorry. Due to some family reasons, my dad passed away 3 years ago. She came to the USA 2 years ago on a visitor visa. What can I do to bring her ASAP on a green card?
You'll do what everybody else has to do. Once you surrender the green card, you are just like anybody who doesn't have a green card. So you'll
Right,
have to reapply for her. But keep in mind what we talked about in the beginning of this conversation about a preconceived intention to stay here.
right. Okay. And would it be helpful if they again send a letter that, by the way, we already had a green? No, that won't really help.
It
Okay.
doesn't hurt, it doesn't help.
Okay. It's just good information that they should know and can work or may not work. We don't know that.
Yep.
Okay. Uh, the next question. What does one need to do or show to get asylum as an Indian here?
If you find out, let me know.
Yeah, that was a very open-ended question.
The thing is, look, I know the general law, but
Right.
I'm not an expert in asylum laws. Asylum is basically based upon a fear that if you go back to your country, you
Mhm.
will be persecuted for your political belief, membership in a social group, things like that. So, for instance, in some countries, gay people are persecuted, so they can apply for asylum here. It's depends upon the country conditions, depends upon what your particular problem is. But the basic idea is, if I go back, they're gonna kill me.
Oh, wow. Okay. You got to be careful with that then. The next question. We have applied for a green card for my brother and his family, applied in January of 2008. My brother's son was born in 2009. How can the name be added into the immigration petition? Petition has already been moved to National Visa Services.
We had a case like that very recently. Basically, just contact the consulate; they should be able to fix it.
Okay.
So there's no doubt if there is an after acquired child, after
Right.
born child, they'll be
Right.
included. There's no problem.
Okay. It's easy to add the child's name in the process. Great.
Yeah.
Let's move on to the next one. I have been here along with my family on F3 visa as my father-in-law sponsored my family.
Oh, F3. So family based. Okay.
Right. Now I have a daughter who's handicapped child who has not been permitted as she is 25 but not married. We have filed her papers, but that too last year. How can we get her here? And anyways, if it could be done in any fast track way.
What we have done, we have a case like this out of New York where the family is here.
Right?
The mother has her green card.
Mm-hmm.
The father lives in Africa, in a country which does not allow easy ingress for non-immigrants. It's problematic to get this child to Africa. There's nobody in India to take care of her, and she's completely dependent upon the mother. She has some challenges.
Right.
So we've been extending her tourist visa for many, many years.
Okay.
I think a couple of years at least.
Right.
So one of the lesser used procedures in tourist visas is situations where, for example, let's say you don't qualify for a derivative visa. So let's say somebody's here on an H1 visa and their mother is alone.
Right.
Mother doesn't qualify for H4.
Hmm.
But we've been extending tourist visas, fully stating, look, she can't be sent back. She's diabetic. She's got to be taken care of. We just need to keep extending her status. And they do.
They do it. Okay. You just need to give them a valid reason.
Right. So that would be one thing I would apply for. Second thing I would also think for is if humanitarian parole is an option.
Okay.
Humanitarian parole is, you just Google, again, I don't want to say Google Yahoo,
They use.
Microsoft search, whatever you do. Go to search for USCIS humanitarian parole.
Okay.
You will know what needs to be done.
Okay.
A process is relatively lengthy, a few months, but it's still something that can be expedited, something to be looked at. So that could be another option.
Okay, and that's a faster process as well, because that's his next question. That is there any way he can fast track this whole process?
Fast tracking, see, the problem is, let's see, F3, I don't know what F3 is. With my family on F3 visa, as my father was sponsored by my family, I'm not quite clear which category this is, but
Okay.
normally if there is a waiting, for instance, there is a priority date lag, you cannot expedite that. You can expedite processing of cases.
Right.
If something is stuck somewhere, you can reach out to a congressman's office and try to get that expedited. But you cannot circumvent the waiting times that are based upon the country you were born in.
Gotcha. Okay. Well, I hope that helps him and he's able to get his daughter here as soon as possible. Let's move on to the next question. My employer in California is making me sign a contract to sponsor my visa. The contract states that if I leave the company within an X amount of years, I'll have to pay the company the entire amount incurred in the visa sponsorship. Is this even legal? How can this situation be tackled better?
I can write a 300-page book on this. It's called the liquidated damages clause.
Okay.
I am not sure we have the time to cover it all, the nuances of it. I'll try to shorten it.
Sure.
But if you go to our website, immigration.com, and then you go to, I think it's underneath either About Us or it's where my biography is, you'll see some of the articles I have written. I've written an article, I think it's a 30-page article for American Law Institute, American Bar Association, called The Validity of Liquidated Damages Clauses in H-1B Contracts. And a shorter version of that was written as an opinion, as an op-ed piece for a legal publication, which is a one-page document. So the basic idea is, if there is a situation in which an employer does not know that the employee's leaving could cause them X number of dollars and the X is uncertain, the employee and the employer can sit down and say, you know what, if we have to replace you in the middle of the project, it's probably going to cost us about $75,000, $100,000 in lost goodwill, $200,000 should cover it. That's called a liquidated damages clause, where parties are getting together to form an estimate of something which cannot be estimated.
Right.
And it's in good faith. And you're not trying to punish the employee. You're only trying to make sure you don't get hurt.
Right.
So liquidated damages clauses are allowed. You studied it legal. Liquidated damages clauses are allowed, reasonable, negotiated, not penalties. But penalties are not allowed, because penalties are a way to restrict somebody from working.
Right.
Okay? But here is where employers go wrong. Who makes the decision whether something is liquidated damages clause or penalty? In H-1B cases, U.S. Department of Labor does.
Okay.
Once the Department of Labor comes into your premises, they can look at everything.
Right.
So smart employers don't enter into these agreements.
Right.
Dumb ones, misguided ones do.
Right.
If you're a smart employer, don't get into these contracts. It's not worth it.
Gotcha.
Now, if you're an employee, what you can do is, if they're trying to enforce that, first download a copy of my article, download a copy of my opinion piece, show it to your litigators if they are suing you.
Okay.
Because there is a very strong argument against, there are two things that can be argued. One is something called preemption, where federal law rules over state law. I'm not sure it's completely an issue of preemption, but something can be, depends upon the state you're in. Look at what their laws are, whether they conflict with the federal laws. And number two, you can file a complaint with the U.S. Department of Labor Wage and Hour Division, WHD, and say, my employer is trying to get money from you.
Right.
Wage and Hour Division should take this matter very seriously. They should step in, they should contact the employer and ask them for an explanation.
Okay.
That can begin an investigation.
Gotcha.
Okay. Is it legal? Maybe. But even to make that decision, an audit will have to be conducted.
Okay. Gotcha. Great. Next question is something that we've been getting very often. it says that I noticed that L2 EAD approval is taking more than 90 days. Is there any way to get EAD sooner?
Every now and then, USCIS very pleasantly surprises us. Let me give you an example. I had a case of an H4 EAD. Normally, we've had to file a lawsuit. I filed a lawsuit a couple of weeks ago or 3 weeks ago for somebody whose H4 and H4 EAD they had been sitting on for 18 months. They approved the case within a couple of weeks.
Okay.
But that shouldn't be a part of the process, right? A few months ago, I had a case in which an H4 EAD needed to be renewed, and this lady was going to be out of work in a week or so. We sent a request for expedite to the government. I was in the office. I got a phone call from the USCIS, from the adjudications office, and he said, sir, your firm has requested an expedite. Can you explain to me what's going on?
Right.
I explained to him, I said, the problem is, if I don't get an expedite, she's working for a non-profit that provides rural electricity to over 80,000 people. She will be out of 2 critical projects, and the non-profit has said we need her desperately for this. And I said, sir, not for her, but she could sit at home and watch TV all day. But it's all those 80,000 Americans who are going to suffer if you don't expedite. He did that over the phone. He expedited the case over the phone. We got an EAD within 3 days.
Okay.
So expedites like that are extremely unusual. Only time in 30 years of my practice where I've seen that happen.
Okay.
But they can happen. So there are certain situations in which expedites are more likely. So for example, if you are doing something for the government, you're doing something for the US workforce, teachers, professors, students are sitting, I can't teach unless I get my EAD.
Yeah.
Or if there is a drastic financial consequence to the employer. Don't argue financial consequence to yourself, because government shouldn't care about that.
Yeah.
If the family can't survive without your H4 income, you're probably deportable. For L2 income, you're probably deportable.
Okay.
So that's not something you want to argue. But if you have a situation that's extraordinary, in which we should make an accommodation, they might expedite.
Okay. We just have a few more questions left. The next one goes like, I'm on B1 visitor visa. If I extend my visa status for another 6 months, are there any problems that I will be facing to enter US at the immigration after my extension?
There are 2 potential issues. One is if you try to come back again too quickly.
Right.
So it shouldn't be, let's say you got your tourist visa extended, now you've lived here for 1 year. Then you go back to India or Japan or China, wherever you're from, and after 3 months you want to come back again. It looks like you are visiting Japan and living in USA. 1 year here, 3 months here in your home country. So that won't work. So don't come back for at least 1 more year.
Okay.
Second thing, consulates are particularly unfond of people who extend their tourist stay. So unless you have a very good reason, don't do an extension. It's not worth it. It can inhibit both your coming back as well as getting visa again from the consulate when you need it.
Okay. The next question. My son got the Social Security, though he's not a US citizen, but the birth date was wrong. So we asked the officers to fix it, but they said he's not eligible. And what can we do if they cancel the SSN? So it looks like they provided the SSN and now they're saying it's not a valid case. It's like
if it was given by mistake and the mistake has been corrected, what can we do?
Oh God. Okay.
By the way, it's interesting. When I came to this country in 1986, my Social Security number was issued while I was still in law school. So my Social Security number, all these years later, still says not valid for employment.
Oh, really? So is that just like a print mistake, which is on the?
It was okay, but combined with my other documents, especially my passport, US passport, that becomes a non-issue. So the SSN by itself is not the only issue. The eligibility is. I gave you my example because mine still says not valid for employment.
Okay. And here you are conducting this session with us on behalf of your law firm.
Here I am thumbing my nose at the government, right?
Absolutely. Okay. Next question. I'm living in Washington. Washington. I am on pending asylum, and I want to move to Indiana, where my case will be transferred. I think Indiana doesn't have any asylum processing office. Oh, so this is more like on a location.
Well, you also said the A word, which I have no idea. Asylum. Asylum is something I'm really, two things never ask me questions about:
Hmm.
political asylum and tax laws. You don't want my opinion on those.
Great, gotcha. No worries. We shall keep that in mind for our future sessions. The next question is, what if someone came to the USA on L1 visa with a good amount of investment? Later on, did not get L1 extension due to not getting supporting documents from US sponsored company and did not get the enough investment in return. Do you have any legal advice to get the investment money back?
I would have legal advice if your investment was in Virginia or DC, where I'm admitted to practice state law.
Right.
This is a state law issue. It's a contract issue.
Okay.
It is not really an issue of immigration law. So the answer would depend upon the circumstances of the case, and you need to talk to a lawyer who practices in the state in which you made the investments.
Okay. Well, at least we are directing you in the right direction. My next question is, I'm on L1B visa. Can I switch companies?
You can, but not on L1B visa. Because, see, L1B visa is tied to a group of companies.
Okay.
L1 is a visa that's called, for your reference, Varsha, because since you're learning immigration law. By the way, practicing without a license is in most states is a crime, so be careful.
I'll keep that in mind.
Don't give legal advice to people.
Yes.
One of my pet peeves is that people will tell me, but Rajiv, I think this is the way the law is. No, I don't think so. Well, my friend told me. I said, listen, if you break your leg, you don't go to your friend to fix it. You go to a doctor.
Yes.
So what makes you think that law is any less complicated than medical procedures? Law is just as complicated. So the problem here is L1B it's called an intra-company transferee, which means it transfer within the same group of companies. So if you
Right.
work for IBM India or IBM UK or IBM Japan and you're being transferred to IBM USA, you would probably use an L1 visa.
Okay.
So intra-company means you've got to stay within the same group of companies.
Right.
So if IBM had 6 companies within USA, IBM products, IBM consulting, you could move within those companies. But if you want to move outside, then you're like everybody else. You got to go for H1B.
Right. So the L1 will become like
Default.
not void. Yeah. Okay. Gotcha. Great. The next question is, how long does it take to receive advance parole after applying for I-485?
Processing times difficult to predict. I would say about 7-8 months.
Okay.
That's the normal as far as I know.
Okay, but I'm sure the person can look up the answers as well and
And even then it's an estimate, it is not
a definitive answer. Okay. The next question, if H1B lottery is picked up in the process starting 1st March and after getting the results of lottery, but before submitting the documents for H1B processes, can we change the company and transfer the lottery results to the new company to submit H1B documents?
I don't know the answer. This is a new process. What they're talking about is, see, the process for the H1B changed this year.
Right.
This year, what they're going to do is they're going to start a lottery with some basic information about the employer and the employee.
Okay.
And they're going to run the lottery between March 1st and 21st. And then if you win the lottery, you start filing your paperwork from April 1st for the next 90 days. My guess is you cannot transfer it because I don't think there's any specific word on that. So far, we don't even know many of the details about the lottery. We don't know.
Okay.
We'll know closer to, I would say, March 1st. But I would be surprised if an employee, it can be, but I would be surprised if they're allowed to take their lottery position to another employer for 2 reasons. One, H1B is the application of the employer, not the employee.
Right.
Okay. And 2, the $10 fees has been paid by one employer.
Yeah.
However, that's not to say that law doesn't surprise you. They can surprise me with exactly the opposite answer. Right now, we don't know, but my guess is you cannot transfer.
Okay. Great. Well, I guess, yeah, we'll know as we get closer to the date.
We hope so.
Right. Moving on to the next question. Can I-140 status be revoked if returned to India?
Yes, but again, if you go to my blog, there is an article in detail
Mm-hmm.
on the new regulations that came into effect on January 17th, 2017.
Okay.
What do those regulations say? Those regulations say that if your I-140 is approved, immediately the priority date becomes your property unless we revoke the I-140 for fraud. You can carry that to any employer, any green card.
Right.
In addition, if your I-140 stayed approved for 180 days,
Mm-hmm.
you can extend your H-1B also indefinitely for any employer.
Okay.
So that means the I-140 can be revoked if the employer so wishes. But if they let it stay in play for 180 days, you would not be hurt in any way that I can think of by going to India or by the revocation.
Okay. Gotcha. Great. Next question. I have a friend on OPT, but unlikely he got late to submit his STEM extension. So he got denied. Then he filed his MTR to reconsider his case. But today only he again got denied, stating that it's his fault, not USCIS. Is there any way he can refile for his STEM extension? And if not, what is the time frame he has to leave the country within?
I don't know the answer to is there any other way because I don't think there is. But I never give a definitive opinion until I've looked at the regulations from every angle.
Right.
Okay. I don't think you have any option.
Right.
If you are late, it's the end.
Yeah.
The question that there was another part of the question, time frame to leave the country.
Yeah.
So the typical time frame for students to leave the country is 60 days after their OPT expires.
Okay. Okay. Cool. That should be helpful. The next question. I'm married to a permanent resident, completed my GC interview waiting for my GC since November 2019. How long will it be before I receive my green card? Secondly, after receiving it, how soon can I travel out of country? And my husband is due for his citizenship next year. Can I also file for a citizenship with him, though I received my green card this year? Is it feasible?
Okay. So how long? We don't know.
Yeah.
But November to March is not extraordinary. It doesn't sound like it's a lot of time.
Long time, yeah.
I would say that around April, May, maybe I would start open an inquiry. Can you travel out the country once you get the green card? Sure, as long as you're coming back and you're not gone for too long. The usual rule of the thumb is try to make trips less than 6 months.
Okay.
Because when you're coming after 6 months, you are treated differently under the law,
Okay.
in a lot more disadvantageous position legally than you are if you are returning before 6 months.
So you tend to raise more suspicious if you take longer than.
Actually, it's a little bit more complicated than that. We could write a booklet on this.
Okay.
It's about the doctrine of entry. So the idea is when you're seeking entry, the number of rights you have are fewer than if you have already entered.
Okay.
So fundamental rights in India or the rights in the United States are available fully to people inside the US. But if you're at the border, you have fewer rights.
Okay.
So green card holders who come after 6 months are considered to be in those categories where they're applying for admission. Coming before 6 months, they're just returning.
Okay.
Okay, the third question was
My husband is due for the citizenship next year. Can I also file for citizenship with him?
you do not become eligible for naturalization until you have completed 3 years after your green card approval.
Right.
So before doesn't matter. Also remember, you can upgrade your petition, although I don't think that's a problem. The priority dates for green card holders are probably current. But if you need to, you can upgrade your petition to the spouse of a US citizen also by just sending a copy of the naturalization certificate and a request to update. I don't think it's going to change the processing time, but it doesn't hurt.
Okay, great. Let's move on to the last question that we have. My family is on a dependent visa. I have a valid H-1B, but need to step out of the country for more than a year. Can my family stay here without me? I wouldn't be on US parole while I'm out. In other words, do I need to be on payroll in US to keep my H-1B active, or is that not required?
It's not possible. Because the idea is that if you're on H1B, the family is on H4 only because you are maintaining status. If you leave the United States, USC has indicated this. It's a tertiary issue of law, not really written down anywhere,
Right.
except in a conversation with American Immigration Lawyers Association. And they said, we consider this to be inappropriate and we won't consider the family to be maintaining status. A few days is okay, but if they're gone for a protected period of time, we won't consider the family to be maintaining status.
Okay, so we need to be careful with that. Okay, great. Well, I guess that was it for this session, Rajiv ji. You've answered all the questions. Thank you so much. And of course, we'll keep our users informed about the next session that we'll host with you. And this time it can be a live where they can directly answer, you can answer questions live. And anything that you want to share with us, any message that you have, please feel free.
Just one thing, and we talked about that briefly, you and Bashaji, that if maintaining your confidentiality is important, you are responsible for it.
Right.
We cannot do anything about that,
Right.
neither you nor us.
Yeah.
So if you folks have figured out a way to participate in a conference without revealing your identity, that's the perfect thing to do.
Perfect.
Because we have no way of protecting your confidentiality. This is not an attorney-client privilege telephone call. So whatever you say can be discovered by the government. Government can send you subpoenas, us subpoenas, if we have information. So please protect your own identity if it is important. If not, then it's all good.
Great. Thank you so much for that piece of information as well, Rajiv. It was wonderful conducting this session with you.
Yes, ma'am. My pleasure.